want to welcome you all to our annual Constitution Day Conference. And on behalf of the Center for Constitutional Studies and Utah Valley University. On September 17, 1787, 39 delegates to the Constitutional Convention signed the document that would, following ratification by the people of the states, become the United States Constitution. September 17th is therefore the day set aside in federal law as Constitution Day. In Utah, of course, not content to do what's expected, the whole month of September is now Founders and Constitution Month. Institutions of higher education, schools, local governments, universities, citizens groups, and other organizations around the state will give Utahns occasions to celebrate and learn about the framers' accomplishment in 1787. Perhaps uniquely, the Center for Constitutional Studies here at UVU is marking the occasion over the next 2 days by celebrating America's rich, ongoing state constitutional tradition. When we talk of our constitutional tradition in the United States, we tend to speak of the Constitution, a single document, a single act of we the people constituting a government. At one level, that's true. The Constitution is a durable frame of government. It's remained remarkably stable for more than 2 centuries. It's weathered political disunion, economic depression, global conflict, and even culture war. We've amended it 27 times, but none of those amendments have altered the basic structure of the government. They have expanded the scope of those who are comprehended by the Constitution's protection or included in the category of we the people of the United States. But its alterations to the government itself have been relatively modest. The American constitutional tradition, though, is not, in fact, as stable and static as the federal Constitution makes it seem. We don't just have one Constitution in the United States. We have, in fact, had more than 200 constitutions written by constitutional conventions, but in the states. This is a remarkably fruitful enterprise in constitution making, and what I think is a really important concept, the notion of constitutional self-government. The Center for Constitutional Studies is deeply invested in studying the creation of state constitutions through our work on the Quill Project and in partnership with our colleagues at Pembroke College, Oxford. Quill is a powerful digital tool created by Nicholas Cole to map and visualize the deliberative process through which a constitution or other negotiated text is created. Quill's digital tools enable a richer understanding of how a text changed during negotiation, who influenced it, at what stage, and what impact this had. For legal scholars, they clarify what writers intended to say and how their words should be interpreted in today's context. For educators, our tools bring to life a story of negotiation and compromise. UVU student researchers have participated in the modeling of the creation of the federal Constitution, the Bill of Rights, Reconstruction amendments and civil rights legislation that followed the Civil War, and Utah's own state constitution. Perhaps most exciting, in 2020, UVU and the Quill Project won a Digital Humanities Advancement Grant from the National Endowment for the Humanities, which has enabled us to digitize and model the deliberations of 5 Western state constitutions, including Washington, Idaho, Wyoming, and the Dakotas, all of which began their deliberations on the same day, July 4th, 1889. Why have we invested such time and resources in the study of state constitutions? And why celebrate Constitution Day and Founders and Constitution Month by focusing on the state constitutional tradition? State constitutions are among other things, more deeply entwined in our daily lives than, for most people at least, than the federal Constitution. State constitutions are also more accessible in the sense that ordinary people have greater capacity to bring about change in their state constitutions than in the federal Constitution. New state constitutions not only more frequently made, the 200 or so I've mentioned, they're more easily amended. It took 2 centuries to pass 27 amendments to the U.S. Constitution. The people of Utah have amended theirs 24 times just in recent years. Recent Supreme Court decisions, moreover, have moved state constitutions and the process for amending them back into the spotlight. I won't detail those things. I'm sure they'll come up. Because state constitutions are closer to the people, more entwined in their daily lives, and more amenable to change, it is critically important that people appreciate their constitutions as part of the American constitutional tradition. And our state constitutions are the part of that tradition that reminds us that constitutional self-government is not an episode in American history. It's an ongoing civic duty that we engage in now and in the near future, I hazard to guess. So we need to be equipped for it. Before I introduce this panel and we get started, I want to make a couple of important announcements. First, if you're one of our colleagues from the legal profession in Utah and you'd like to receive CLE credit for this, please do make sure you sign in on the CLE list on the registration table just outside this room. Secondly, if you're a student and you need to leave the session early for class, please exit quietly, preferably when we transition from presentations to questions to Q&A, or a question and answer time. And finally, I want to acknowledge and thank the National Endowment for the Humanities, especially the Office of Digital Humanities, for making this conference possible through their Digital Humanities Advancement Grant Program. We're deeply grateful for this opportunity, and we applaud and join with the NEH as it pursues its mission to serve and strengthen our republic by promoting excellence in the humanities and conveying the lessons of history to all Americans. Now, our first panel this morning, which I'm very excited about, includes 3 leading voices in the study and practice of state constitutional law. They're with us to discuss the relationship between state constitutions and the work of the state and federal courts. Leading the discussion is the Honorable Christine Durham, who served the people of this state as a justice of the Utah Supreme Court for 35 years, including 10 years as Chief Justice. A graduate of the Duke University School of Law, she's taught at BYU's Reuben J. Clark Law School, the U's S.J. Quinney College of Law, and, perhaps most interesting, the Duke University Medical School. She is currently Senior of Counsel in the Salt Lake City office of Wilson, Sonsini, Goodrich, and Rosati. Joining Justice Durham is the Honorable Jeffrey S. Sutton, Chief Judge of the U.S. Court of Appeals for the Sixth Circuit. His circuit includes the states of Michigan, Ohio, Kentucky, and Tennessee. That's right. He has served on the Sixth Circuit since 2003. He clerked at the U.S. Supreme Court for both Justice Scalia and Justice Powell. He regularly teaches state constitutional law at Ohio State and Harvard Law Schools, and is the author of the book, 51 Imperfect Solutions, States in the Making of American Constitutional Law. And the final member of our panel is Robert F. Williams, Distinguished Professor of Law Emeritus at Rutgers University. Alongside his colleague Alan Tarr, Bob has done more to inspire scholarly attention to state constitutions than anyone in the field through his work as director of the Center for State Constitutional Law at Rutgers. Among his many scholarly works is The Law of the American State Constitutions, of which I think a new edition has just become available from Oxford University Press. So run out and buy it quick before it sells out. Well, I am humbled and delighted and quite excited to introduce this panel, and I hope you'll join me in thanking them for joining us, and I will turn it over to Justice Durham.
Thank you very much for that kind introduction. Can you hear me on the back row? Good, thank you. Let me begin by asking just a quick thought question. Aside from the speakers and presenters here at this conference, how many of you know what is the oldest extant constitution in the world? Anybody want to guess? Anybody thinking the Constitution of the United States of America? Because that's not right. The answer to that is Massachusetts. The Massachusetts Constitution not only was drafted before and is still extant and in operation, the federal Constitution, but a great deal of the work that went into the structure and content of the Massachusetts Constitution subsequently became a big part of the conversations and the discussions concerning the federal Constitution. When I was new on the court back in the 80s, I was asked to make a presentation to the government lawyer section in Utah, and I talked about state constitutions at that and the fact that they were significantly neglected in the litigation that we saw, aside from provisions that had no federal analog. And during the question and answer period, one of the lawyers stood up and said, well, the problem is there's so little state constitutional analysis in the case law of our state. So couldn't your court just tell us what you want us to argue, and then we will know what questions to bring to the court? And my response to that was, that's not really the function of a court. We have an adversarial system, and the parties and their lawyers are supposed to bring the issues to the court. So my reward for raising that whole question was to be asked to teach state constitutional law at the University of Utah, which I did for about 10 to 12 years until I couldn't deal with the other responsibilities I had and still continue that. The problem is that no one has replaced me in the couple of decades now since. So it's wonderful to see state constitutional law emerging as not just a legitimate, but a much more widespread subject of scholarly work. We have, as has been mentioned in the introductions, two people here who have been as responsible as probably anyone in the field for focusing on the issues that need to be taught, not just to law school students, but also to anyone who is interested in civic education, because we have what is known as a federalist system. And the federalist system requires balance and exchange between the federal government and the state governments. And the state constitutions are what structure and include the state governments. It's one of the things that's so fascinating is to find out things about state constitutions that you never know. I'll bet you didn't know, most of you, that here in Utah, we have one of the relative handful of equal rights provisions based on gender as well as other elements. So even though the state of Utah has never managed to get around putting an equal rights provision into the federal constitution, we've had one in Utah since statehood. So that's the kind of little nugget that you can pull out of the study of state constitutions. Today we're going to ask Judge Sutton to begin, because he can give us, he's really taken a very historical scholarly approach to the interaction, the notion of judicial federalism, the exchanges that go on, the law that is actually generated under state constitutional provisions that eventually enters the federal lexicon in the way in which we have that collaboration between the branches of government. And I think we're gonna be informal. We may interrupt each other to ask questions, or, but when Judge Sutton is finished, we're gonna ask Professor Williams to talk perhaps about some illustrative incidents and cases that will give us a better picture of what's going on. So, turn it over to you.
All right, thank you, Justice Durham. It's an honor to be with you and Professor Williams, Christine, Bob. These are the true people in the field. She actually does it by being a Utah Supreme Court justice. Now that she's in practice, I'm sure she's doing quite a bit of state constitutional law. And Professor Williams has been doing this. I don't want to err in the wrong direction, but I also don't want to understate it. I think it's 50, 60 years. Am I in the ballpark?
1926.
I'll go with, so 50 years it's a great lesson. I'll bet, Bob, there were years where no one was doing anything on state constitutional law, and if you tried to put together a conference, people would have looked at you like you had three eyes. But it's a great example of what persistence does, because he's been in the vineyards doing this since the 70s, and suddenly we're in this moment where, I can tell you, I get probably 2 invitations a week to speak about state constitutional law, and I just promise you 10 years ago that wasn't happening. So it's a real honor to be with both of you. And I thought what I would do, just as an introductory matter, is try to figure out why. What is it now that's going on that has conferences like this, centers like this, people focusing on this? Well, the day we're celebrating illustrates the past, the reality that in this country we've always called it Constitution Day proves our utter and complete ignorance as Americans. It should be Constitution's Day, plural. At a minimum, I don't understand why you wouldn't celebrate your own state constitution and the federal one, or if you're like me, all 51. So that kind of confirms the problem. And I can confirm the problem with a more recent anecdote. I went down, I'll talk a little more tomorrow about how I started down this road, but I did start down the road of getting interested in state constitutions about 10, 15 years ago, and finally got around to writing a book. And that experience illustrates the past, at least within my family. So I write this book. I'm trying to make it super accessible so people like you would like to read it. It's got lots of fun metaphors and analogies, and I just think it's as good as it can be. And I happen to be married to a 7th grade English teacher who's a great writer and also very good at grammar. And just as we're about to send the book off to the press, it's a Friday, I say, Peg, would you mind giving the whole thing a read? I know this isn't your area, but you're just such a great writer, and maybe I have a dangling modifier here, a verb subject disagreement problem there. And she's just really good at catching that stuff. So I give it to her on a Friday, and on a Sunday I say, well, how's it going? Well, she's like halfway through the first chapter. Mind you, the first chapter is like 6 pages. So she has read 3 pages in 3 days. And I said, Peg, I thought it was a little more of a page turner. And she looks at me with way too much seriousness in her eyes and says, Jeff, I don't love you that much. In other words, I don't care how long we've been married, this is too much to ask of me. Now, she hates it when I tell that story, and maybe the proof is she does love me that much because she felt guilty and eventually she did read it. But my broader point is she's now always sending me articles about state constitutions. The New York Times, just yesterday had this piece, or maybe it's running today, and she'll just quickly, isn't it amazing? And so something changed in the last 5 years, and I just want to try to see if I can put my finger on it. Well, one way of thinking about the past and Constitution Day and how we think about constitutions is what is sometimes you can call the danger of the single story. Now, that's often used to describe the way people interact with each other, and we often too quickly start to assume someone is just this. They're just about their faith or their geography, where they're from, or their gender, whatever it might be. And of course, we all had the experience of the more time you spend with someone, you realize there's not one story, there's quite a few. Well, in federal con law, that has been our plight. It's the danger of the single story, that we Americans think there's one Constitution that protects our rights, one guardian of that Constitution, the great U.S. Supreme Court and its 9 justices. And, as a former 7th grade teacher, I kind of understand how civics teachers, it's hard enough to teach a 13-year-old separation of powers and federalism. The idea of teaching them about the 50 state constitutions, I get the point. But it's highly misleading because educated and non-educated alike really think we've just got one story of how to protect our rights and one guardian of those rights, the U.S. Supreme Court. And it just turns out, as is often the case when you have single stories, they have lots of legends, myths, and falsities. One myth that grows out of the danger of the single story is that the U.S. Supreme Court, this guardian, is always right. Now, the court on balance has done pretty well over American history, but I think you all know they're not always right. They weren't right in Dred Scott. They weren't right in Plessy. There have been some recent decisions that I'm sure some of you might disagree with. The other danger of the single story is the assumption that the states can't ever get it right, or state court judges or junior varsity, second-class judges when it comes to protecting liberty and freedom. Turns out that's false as well. One of the things I've spent a lot of time writing about are the times in which the state courts have been the greater guardians of liberty than the federal courts. I'm a federal judge. I'm not even protecting my own here. So there have been many times in history that, if you know the Buck versus Bell eugenics story, that's a great example where the state courts saw what was wrong with involuntarily sterilizing individuals with disabilities. The federal courts did not see the problem. The state courts did see the problem. Another way of thinking about the danger of the single story is that the U.S. Supreme Court in some ways has been a victim of its own success. The greatest case in American history, the one you all know, you probably knew from 13 on, is Brown versus Board of Education, which, remarkably in a 9-0 decision does so much to bring Jim Crow to heel and get us kind of on a path away from racial segregation, the path that started with slavery, of course, allowed in the original Constitution, and getting us more and more away from that, deep sin in American history. So the court, of course, deserves a lot of credit for Brown, but it doesn't mean the court is the only place to go to protect equality, liberty, and so forth. So that's the past. That's the single story version of American history. Why is it that people, even my wife, are now realizing there are 51 guardians of liberty and equality? There are 51 constitutions. Well, I think there's a couple things going on, and you people in school right now are in an incredible time in American history where you're really going to have an opportunity to do something with this change. So one obvious thing that's going on is the U.S. Supreme Court currently is less likely to innovate new rights. There's no other way to put it. They're more conservative, if you want to use that term. It just doesn't matter, but the reality is they're less likely to innovate. When you have a court that is saying no to new rights claims, you suddenly have the option as an American citizen of embracing unhappiness and just saying, well, it's kind of fun just to complain, or say, well, wait a second, maybe we have a second option here. And maybe that second option still involves the courts, maybe it still involves constitutions, maybe it still involves due process, equal protection, free speech guarantees, and you go to state court and you seek the very same relief that was denied to you in the U.S. Supreme Court under the U.S. Constitution. And so that, I think, this second shot opportunity, the reality that every American can challenge a state or local law they don't care for, state or local prosecution they think is wrong. Every American has two shots, not one, to stop the government in its tracks. And it seems to me, with a court that, say, is issuing decisions like Dobbs, deciding we're going to put a big red stop sign, we are not going to be in the business of deciding when there's a right to get an abortion or not. There's a case called Rucho, which is almost as important, which says stop sign. You cannot come to the U.S. Supreme Court if you think your legislature is unfairly gerrymandered its districts. Well, what we've learned in the last, barely, not even 2 years since Dobbs, and about 5 years since Rucho, is that a lot of state courts are willing to take up the mantle and do something with those issues, to say nothing of other issues. I'll give you another example of an issue that I think the people of Utah would probably be somewhat sensitive to. There's a very significant U.S. Supreme Court decision called Smith from 1990, written by my old boss, Justice Scalia, where I think you'd call it a pretty stingy interpretation of the free exercise clause of the First Amendment. That's another case where the U.S. Supreme Court puts up a big red stop sign and says, we're not open for business in protecting this liberty interest unless you've got something quite extraordinary going on. Well, since 1990, state courts have realized they can use their free exercise provisions to protect rights the U.S. Supreme Court didn't protect. And that leaves just one other option. Then I'll turn the microphone over to Professor Williams. Much as I love judges, much as I love constitutions, I think there's another single story problem we have here, which is the assumption that judges and courts are the only place to go to protect our rights. This is the great counter-majoritarian theme in American judicial review and American judicial history. You know, I'm proud of it. I couldn't be more proud of the federal court's role in Brown. But I sometimes think it's a little overrated. I sometimes think the thing we as Americans should really be doing is using the democratic process to protect rights. That, you know, getting 5 justices on the U.S. Supreme Court, 3 justices on the Utah Supreme Court, it's great if you win, but is that really the way to dignify a right, particularly when it comes to evolving norms? I sometimes think the better way to protect minoritarian rights is actually the democratic process, and this is how I'll close to make the point. Speaking of single stories, if I can only pick one or the other of these 2 landmark events in American history, Brown versus Board of Education or the 1964 Civil Rights Act passed by Congress, I only have one, so don't give me the genie, can I have another guess or another wish? Can't do that. You're stuck with one or the other. If I only have one of those options, I would always take the 1964 Civil Rights Act. Now, why do I say that with such conviction? I love Brown. I'm not denying the point. But what's the goal? What is the point of being an American? Is the point of being an American that we're going to have liberties and equality provisions protected by 5 out of 9 life-tenured justices interpreting a constitution that can't be amended? Or is the point to go to our neighbors, work in our communities, and decide that it's an American value for a majority of Americans to look after the minority, whether it's a minority faith group, race group, gender group, whatever it might be? And that's what's heroic about the '64 Civil Rights Act. It was a majority of Americans through the representatives in Congress saying, we're going to protect these rights through the democratic process. You don't have to rely on the courts alone to do this stuff. Let me tell you something that will never be changed. The 1964 Civil Rights Act. It might be added to. It ain't going to be diluted. Rights at the court, it's just you're one new court away from someone deciding that's not our theory of interpretation. We're going to let the democratic process do it. When you earn the right through the democratic process, it's much more likely to be stable. All right, Professor Williams.
Thank you, Jeff. And let me just follow up and point out that even after Brown, desegregation didn't happen. It took years and years and years of the democratic process to bring that about.
The roots
and
are
the
deep.
Civil Rights Act.
The roots are deeper in legislation than they are in court decisions. They've got to be 5 justices versus Congress and a president who signs it.
Well, thank you. I want to say it's wonderful to be here in your beautiful state of Utah. I would have killed to study in a building like this with a view like that. I think I looked out at the side of a brick building or something when I was in college. But I'm very pleased to be here in this moment in our constitutional history. And I think this morning may prove to be my 4th or 5th unsuccessful attempt to follow Judge Sutton. But I know I have another crack at it next month in South Carolina, so I'm hopeful. But I'll give it my best. Here, if I were writing this up, I would call the title of this talk, "It Could Have Been Worse, the ticking time bomb of Moore versus Harper." a United States Supreme Court case that was decided earlier this year by the United States Supreme Court. And I think it fits within the theme today of the 51 constitutions in American federalism, and the fact that the state constitutions operate within the supreme law of the land of the United States Constitution. And state judges operate within the context of both of those constitutions, and that relationship sometimes changes. And I'll explain it this way. The so-called elections clause of the United States Constitution, I'll give you the site if you ask me afterwards, basically says that the time, place, and manner of federal elections will be governed by the legislatures of the states. And when I talk to people in other federal countries, interesting groups, Switzerland, Mexico, South Africa, 16 or 17 of them, they go, Bob, you let the states run your federal elections? Are you nuts? And I say, look, we might not have had a country without one of those many compromises that were made to satisfy state interests that they could agree to this new constitution. So as a consequence, for 200 years, we've had state statutes and state constitutional provisions governing federal elections. And for over 200 years, that's been considered the domain of state law. And state law in our federal system is final. The U.S. Supreme Court doesn't have jurisdiction to hear cases that are based on an adequate and independent state ground of state law. Just can't hear those cases. So the glimmering of a contrary view arose in the famous case of Bush versus Gore, which took place when my wife and I were in Tallahassee. So all of this talk about the state court and the state appellate court, and we were sitting right in that 5 or 6 block area. And there was a glimmer of the idea of wait a minute, federal elections take place according to state law, but it's because there's a federal constitutional delegation of that authority to the states. And it really didn't affect too much the outcome of Bush versus Gore, which many of us had our own opinions about. But it really, this theory, it's the so-called independent state legislature theory, arose with a vengeance in the 2020 federal elections. And let me take one example. In Pennsylvania, there's been a clause in the Pennsylvania Constitution, it's in North Carolina also, that I'll mention in a minute. There's a clause that says, quite simply, all elections must be free and equal. Very simple. It's been in these constitutions since 1776. So whatever that is, 11 years before, well, 14 years before the Federal Bill of Rights. And in Pennsylvania, during COVID, the Pennsylvania Supreme Court said, you know what? The state law that governs these federal elections says you have to turn in your ballots on such and such a date. The Pennsylvania Supreme Court took a case saying, you know what? In COVID, maybe it'd be free and equal for our elections to allow the ballots to be turned in 3 or 4 days later. I forget what it was, 3 days, maybe. And that was the law of Pennsylvania. But members of a certain political party saw that as potentially a federal constitutional issue. That, wait a minute, the election clause of the U.S. Constitution says federal elections will be governed according to what the state legislature says. What are these state courts doing being involved in this matter, interpreting state constitutions? The federal Constitution says the legislature does it. counter-argument. For 200 years, it was understood that state legislatures were created by state constitutions and were limited by state constitutions, excuse me, and that was state law. So this teed up the question of maybe, in fact, federal elections raise federal questions that can be heard by federal courts, including the United States Supreme Court. So it didn't come to a head around the 2020 election, but a couple of years later, the Supreme Court did take a case, a gerrymandering case from North Carolina, which had the same clause from the same year, 1776, and the North Carolina Supreme Court ruled that hyperpartisan gerrymandering of state legislatures was unconstitutional under the state constitution. The losing political party asked the United States Supreme Court to take that case, and the court did, to decide this independent state legislature theory. In other words, again, whether state constitutions interpreted by state courts had any role in, in federal elections. This case was described by a very conservative retired federal judge as the single most dangerous case for democracy in our country's history. I saw this, and I worked on my first United States Supreme Court amicus brief, which we did submit to the court. I bet a lot of people here have never seen a U.S. Supreme Court brief, so I thought I would pass one around. Please return it ultimately, but I thought particularly the students might not have ever seen these little pamphlets that hopefully influence the United States Supreme Court.
So you want to know.
Sorry?
You want to know. You're undefeated.
I'll take that, yes. But I listened to the oral argument. You can tune into oral arguments in the U.S. Supreme Court. Quite fascinating. The opening statement by the lawyer arguing again, a lot of you see him on MSNBC all the time, Neil Katyal, the former Solicitor General of the United States. He said, Your Honors, the blast radius of this case is incalculable. Essentially, one of the political parties was taking the position that whatever state legislatures enacted that would apply to federal elections could not be challenged under state constitutions, and even state laws couldn't be interpreted by state courts, that it was whatever the legislature said and that was it, which goes against our whole American idea of separation of powers. And this is why I say it could have been worse. The U.S. Supreme Court rejected that theory 6-3, but at the end of it, and wrote a number of things in its opinion that I and others, I have to say, had put in our briefs. But then at the end of the opinion, the majority opinion by Chief Justice Roberts said, oh, but by the way, there could be a circumstance where a state court engaged in judicial review of a state law or a state constitutional provision that exceeded the bounds of traditional judicial review. And that would be a federal question that federal judges and the U.S. Supreme Court could take up. So this is why I say it's a ticking time bomb. Again, that involves the relationship between federal constitutional law and state constitutional law, and involves the relationship of state judges and federal judges. Because I think when we come up to the 2024 federal elections, there are going to be a lot of people who are dissatisfied with the state courts, the 50 state courts' interpretation of their election laws, and the 50 state courts' interpretations of their state constitutions in the context of federal elections, and are going to want to go to federal court, ultimately the U.S. Supreme Court, to try to argue that the state court decision exceeded the traditional bounds of judicial review. And what I think is dangerous about that, and I'll end here, I think we should all watch for this. I hope I'll still be living at that point, is that this is a very unusual example of federal courts interpreting state law. There are a couple of other examples where, I'm not going to go into them, there are a couple of other examples, and this now constitutes the fourth or fifth example. So it seems to me we could have a situation where federal judges are, including United States Supreme Court justices, are according to them validly, because they're interpreting the federal constitutional election clause, could start to say, well, wait a second, these state courts, they're not interpreting their state constitutions according to originalism. And of course, many federal judges think originalism, what liberty meant back in this case, 1867, I guess, for the 14th Amendment, whatever it meant back then. So I think we have the possibility, or plain meaning interpretation. We're not going to look at constitutional history. It's possible. I hope it's not going to happen. It's supposed to be a very unusual thing to happen, but we could see a whole new round of federal court, I would call it interference with state law here. So we're gonna live through this interaction of federal and state constitutional law.
It's an absolutely fascinating example of the operation of judicial federalism on the ground. I mean, really, the debate that Bob has articulated goes to the fundamental structure of judicial federalism and the relationship between the state governments and the federal governments. So typically speaking, one of the reasons that the federal courts don't review state court interpretations of their own state constitutions is that the state courts, under their own constitutions, have been granted the authority of judicial review, which is also true in the federal government, of course. The federal government can override the legislature on federal constitutional questions. So the history of this has been that if the state court declares that the state constitution forbids the application of statutory language or other action by the legislature, that's the end of it. The United States Supreme Court doesn't have jurisdiction, as Bob made, to reconsider it. So to go behind that history and that structural understanding, which has been extant throughout most of our history, I mean, the notion that this case is a time bomb of huge proportions is quite scary. And it also impinges on one other aspect. State constitutional interpretation is different in a number of significant ways from federal constitution, especially when you're talking about rights. The Bill of Rights in the federal government is a so-called negative grant. In other words, it doesn't say you have a right of free speech. It says that the government can't prevent you from exercising free speech. In the state constitutions, the language is almost universally different. The Bills of Rights in state constitutions are a list of the rights citizens have. And that has an impact, I think, on the ways in which state judges approach interpreting rights under the state constitution. I think they don't have the same dynamic as the federal courts have to. So I'll turn it over. I bet Jeff has some thoughts too.
Well, I thought I'd talk a little bit about Moore versus Harper, and then just a feature of state constitutional law that I think most people don't appreciate. So this is a really big case. We're going to hear more about it. I'm glad you're 1-0 at the court, and you prevailed. I'm probably not quite as worried about this exception that all nine justices embraced it. I mean, it's a pretty diverse court, and all 9 justices agreed that if a state court, for example, interpreted a state voting law to say you got to vote by Tuesday, they couldn't construe it as Wednesday. I mean, that's just making it up, and that's not interpretation. And I think the court was really holding out for that problem. We'll see what happens. But I think what supports that view is you have to remember the Biden administration, you could listen to this presentation and think it's a polarized political thing going on. The Biden administration agreed with that exception. So I think actually everyone in the case agreed with that exception. Now, how big the exception is the $64,000 question. But I thought I would just point out, and I think I'm a huge fan of state courts. I think the federal courts are much more likely to get it wrong than the state courts. So I'm not as worried about this. I think they're going to do their job, and the federal courts will stay out of it. But I wanted to mention one other thing, which you could, Moore versus Harper, super political case, right? It's about gerrymandering, and we all know that's about power, who controls this legislature, Congress, whatever it is. But this is one of my favorite, this may be my favorite thing about state constitutional law. Find me something in American life today, particularly government life, which isn't deeply polarizing and has an RD, blue, red, whatever it is, divide to it. State constitutional law, particularly, federalism in general, is ultimately completely neutral. It has no political valence one way or the other. Sometimes U.S. Supreme Court decisions, like the Smith decision, fail to protect what some people might call a conservative right, free exercise. Sometimes the U.S. Supreme Court fails to protect a right to abortion, might be perceived as a liberal right. They do it in both directions, and the state courts are there to fill those gaps, whether they're conservative gaps, progressive gaps, you name it. So if you ask me, it's a really wonderful feature of state con law. In fact, what follows from it is every method for interpreting the federal Constitution. So what I'm doing, what the U.S. Supreme Court does, every method out there today has reason to look to state constitutions and state courts. So Professor Williams referred to originalists, people that think that the Constitution has a fixed meaning, and I should put my cards on the table. I'm kind of in that camp, roughly. Well, if you think the Constitution has a fixed meaning, you better go to the source code for the Constitution. Guess what the source code for virtually every provision in the federal Constitution, where that comes from? It comes from a pre-existing state constitution. The framers in Philadelphia didn't originate anything. I mean, I don't want to call it plagiarism. That seems a little unfair. But cutting and pasting is not an exaggeration. Picking and choosing among state models, not an exaggeration. So the originalist has to go to state constitutions and state courts. What about the pragmatist or the living constitutionalist? Well, they can't just look in the mirror and decide the Constitution means whatever they see in the mirror, i.e. their own worldview. If they think norms in society have evolved, and if they think those norms are captured by general phrases in the U.S. Constitution, they got to look for evidence outside their own worldview for that shifting norm. Where better to look than state constitutional amendments, state court decisions, and state legislation? So it's utterly an apolitical doctrine. It favors right, left, and every method of interpreting the federal Constitution has reason to look to it. So you can understand why we might be in the middle of a growth area. And now I'm going to tell a story which the two of you I think will be quite intrigued to hear. The only person that did more for state constitutional law than Christine Durham and Bob Williams, and I'm not even sure more is the right way to put it, I'd say is in the same category, is this fellow named Hans Linde, who was a professor, so he kind of had both. He was a professor at Oregon's law school, and he was a justice on the Oregon Supreme Court, and he was a huge proponent of state constitutions. For me, I'd read so much about him, and he passed away about a year or two ago, but when he was in his early 90s, I got one of his former law clerks to introduce me to him. So I went out to Portland, to the retirement home where he and his wife were living. And Hans, I mean, he probably is 5'4". I'll bet he weighs 90 when he's wet. I mean, he is just it was like going to Mecca. I was just so like, oh my gosh, this is Hans Linde. I can't be any better. So I had to really maximize my time with him. And so I go right to it and I say, Hans, it's so interesting. You know, I'm perceived as a conservative. You're perceived as a progressive. how is it that we both love state constitutions? How did this happen, and why do you like them so much? What about a guy from Portland, Oregon would make them want state constitutions to be really important in American government? And he goes, oh, Jeff, it didn't start in Portland, Oregon. So he was born in pre-Nazi Germany, father a lawyer, Nazis come to power. By the way, what's one of the first things Hitler does? It's so much fun to show that you're the opposite of Hitler when you're doing something. What's one of the first things Hitler does? He eliminates German federalism. He gets rid of the states, state constitutions, one national government, one size fits all, of course, one Führer. So Hans Linde's lawyer father, by the way, they're Jewish. They see the writing on the wall. Hans sends the family to Copenhagen, Denmark, not far away, but not in Germany. So mother, and I think it's 2 kids, so I think Hans had a brother. So the 2 kids, they're young. You can imagine how traumatic this is. Father stays in Germany. They're there for a few years. Finally, father says, we're out of here. And they leave and they go to Portland, Oregon. And Hans says, when I look back at my childhood, it's not so much the obvious negativity of Hitler in Germany. That's pretty easy stuff. It's that Copenhagen and Denmark were this community where, perhaps because it was small enough, I think this was his insight, perhaps because it was small enough, everybody could kind of figure out how to get along and how to put together laws, protections, constitutions that kind of made sense for that group. And I think part of what he was worried about is the bigger the community gets as a matter of geography, different cultures, history, kind of the harder it is to have that community point. And so when he becomes an adult, he has this really successful career. His goal was to make Oregon, Denmark. And you know, there's a lot to that point, that we're much more likely to be able to create communities where we're really respectful of each other, really understand each other when there's a little more proximity than when you're talking 330 million people in this really big country. It doesn't mean we can't have one country. Federalism is both. It's not one half, it's both. But anyway, that I always love that story because it proves it's not political, right, left, and he actually was someone that saw the other side of it. He almost, you know, it was almost fatal, right, to be Jewish in Germany and see federalism collapse and what it means to have one Führer, no separation of powers. So, you know, next time you lament separation of powers, remember Nazi Germany.
2 points. First of all, I had the privilege of having Hans Linde as a mentor and spent a lot of time with him when I was a young judge. But my second point is perhaps a little more negative. You talked about neutrality, and one of the things that concerns me enormously is the degree to which the selection systems for judges in this country threatens neutrality on the bench. The federal, well, it's true. It's true in both the federal system.
Yeah,
and the
I've got a lot
system.
of. I can take some. I've got some scars on my back if you want to see it. The federal process is not apolitical.
It has not been apolitical, but in a majority of the states in this country, it is explicitly political. Judges run. If you ever drive through Nevada during election time, you'll see all the billboards for justices on the Supreme Court and their trial judges as well, and they've got big R's or D's on their billboards and so on. And there's been a lot of attention in the press, and scholars are picking up on it, at the politicization of state Supreme Courts in particular, and the dark money that is being funneled into their elections. And all we have to do is watch Wisconsin for the last little while to get a really good illustration of that. So one of the things we have to think about as we're thinking about states and the interpretation of state constitutions is the way in which we ensure neutrality for our state Supreme Courts. And in Utah last year, the legislature passed a bill changing one thing in the selection system. We're one of the merit selection states. People don't run, they run for retention later, but not for selection. But the original statute had specific language in it requiring all of the people put on the selection system had to be nonpartisan. In other words, not that they couldn't have political affiliations, but their political affiliations were not to be a part of the commission's work. They took out the word nonpartisan. for the judicial selection system. It's a nose in the tent for our state to, I think, get more conservative influence.
Let me make one point.
Or liberal down the road, who knows?
That's right. It could go either way. One quick point, because we want to open it up to questions and answers. One point that Judge Sutton made illustrates my ticking time bomb point. He said if you're interpreting a state law that says you have to cast your ballot on Tuesday, a judge can't interpret that to mean Wednesday. But the case in Pennsylvania, the state law said you had to cast your ballot on Tuesday, and the state Supreme Court said that was unconstitutional under the free and equal election clause because it was COVID and people couldn't get their ballots in. You could disagree with that. And that therefore they should get 3 extra days as a matter of constitutional interpretation. That case was taken to the United States Supreme Court, which did not take up the case, and Justice Alito wrote a separate opinion saying that interpretation of the Pennsylvania Constitution was preposterous. Not his word, but in the current terminology, exceeded the bounds of ordinary judicial review. That's the ticking time.
I think you're right, Bob, that's the case that got them onto this. They were very frustrated by that case. Justice Kavanaugh wrote something a little later in another case and said we got to do this outside of an election cycle. Happily, they did do that with Moore versus Harper. It did work out that they were able to do this in a thoughtful way without the rush of, because that was what they were being asked to do in the Pennsylvania case, which really is nerve-wracking. You know, what I'd like to say about, I did use that example for that exact reason, but for me, it doesn't bother me because I thought that was, a COVID emergency thing where if you have governors issuing emergency orders, it doesn't seem preposterous to have state courts issuing emergency orders. Of course, we may now be in a world where COVID is with us forever, in which case we're back to your concern that this is going to happen. So who knows? It's a great point. The only thing I would say, the Wisconsin race was really, I want to be careful here as a sitting judge. I don't want to be too judgmental in either way. What was striking about it was just how relevant it was to the voters, what the different candidates were likely to do, not on every issue, but roughly, let's say, the 5 most salient issues: gerrymandering, abortion, labor union issues. That really was quite striking. Now, the thing I think that is difficult is, I got to tell you, I do not think the federal selection process is any purer. I don't think I really just don't see it. It's just a different form of politics. Federal judges these days are not getting votes from the opposite political party for virtually any judgeship. It doesn't matter whether it's U.S. Supreme Court, my Court of Appeals, or district courts. It's just almost exactly partisan in terms of Congress. So, we judges can go around saying we shouldn't have blue and red robes, we're doing neutral things, but if the people are watching their representatives vote that way, you have to wonder. Now, to me, the only answer to that is it takes you back to maybe it proves we judges, state and federal alike, are just doing too much. We just got to pull back a little bit and let democracy do more of what democracy does. It's not unfair for the American people to care who the judges are if the judges are making really big decisions in their lives. That's America. It would be very strange to say they can't be upset about that and respond to it by whom they vote for president, whom they vote for Senate, or what they do in a state judicial election. It's if you ask me, it's common sense. So I think it might prove that federal and state judges alike, and this is a very apolitical point, maybe our footprint's gotten a little big and we ought to shrink it a little.
Well, we have covered, thank you for that point. We have covered a lot of ground here, and we've got 15 minutes left. And surely there's something that one of us has said that has raised a question in your mind. And this is the chance for you to ask a question about what we've talked about, or if something has occurred to you that we haven't talked about, this would be a good time to raise it.
I'm going to interject one thing. We do have a live stream, so I want you to be aware that we're live streaming the panel. So whatever you say is out there for the world. Maybe I should have told you all before we started. It was in writing, in fine print, somewhere in the materials beforehand. I figured you were lawyers. But in all seriousness, we do have microphones. We have some students from the Center for Constitutional Studies have microphones. So please, if you want to ask a question, raise your hand. Let them come to you.
Please stand when you ask your question so we can all see.
That would be great. And speak directly into the microphone so that we can hear you and so that the world out there in YouTube can hear you. So it looks like we've got one up in the back right there. So Eliza's on her way.
Good morning. So I have 3 questions, but out of consideration for the other students, I had to pick one. What specifically are the collateral benefits of improving state and federal constitutional law? And this is for all of you guys, but specifically to Judge Sutton.
One of the great things about American judging is that we have to explain what we do and why. I'm very proud of that as a judge. We don't just vote yay or nay. We're for an outcome or against it. So one thing that I think is really important, and Justice Durham knows this full well from her time on the Utah Supreme Court, is for a long time, when I say a long time, 50, 60, 70 years, there hasn't been frankly, enough independent thinking about how state courts should construe their own state constitutions. You know, I'm not in a position to assign you anything, but if you get a chance, read your Utah Bill of Rights, Declaration of Rights. They're usually in Article 1 of your state constitution. You're going to see a lot of different language. You're going to see more rights than are in the U.S. Constitution. And so one thing I think that just needs to happen is it's really a basic civics point, that we don't put all our eggs in one basket. We realize there's the U.S. Supreme Court, there's the Utah Supreme Court, there's Congress, there's the Utah legislature, there's the president, there's the governor of Utah. There's an awful lot of ways to fix problems in your community, and there's local governments. Sometimes the very best thing to do is to solve the problem at the very local level of a city government. But if I had one goal, and I bet Justice Durham shares this, it'd be really wonderful for state court judges to continue developing their own approaches to interpretation, their own kind of state-specific doctrines. They're very different charters, the state and federal constitution. So to me, that would be super healthy. But it's probably not going to happen without lawyers knowing what state constitutions are. And we got a group here who, maybe a handful of you will be in law school before we know it. You're not going to make that mistake. Why would you be half-equipped to win a case on behalf of your client? I would think the goal is to be duly equipped.
Just a specific example on that last point, we had a case involving a search and seizure question, and the lawyers briefed it only under the federal constitution. And under the federal search and seizure rules, we voided the search as being unconstitutional. They took it up to the U.S. Supreme Court. We got reversed 9-0. So not only did we get reversed 9-0, but that lawyer lost that case, because obviously if he'd argued it under the state constitutional provisions, they would have won, and it would not have been appealable to the U.S. Supreme Court. More questions?
Thank you so much. This has been amazing. I think my question is about interpretation and kind of the stability of like a range of interpretation. It seems ironic to me that one of the points of having a written constitution was to provide a little more stability in terms of the framework of law, and yet we're at this point where it just seems like we can't even agree on what we're doing anymore with words on a page. It just seems like we're back to an oral tradition and just competing forms of that, using the text as a means rather than interpreting it. In the state constitutions, is it more just lack of a development of tradition of interpretation, or what's all your senses of a stability and maybe some differences in terms of where some states have stability of interpretation of the Constitution?
This is such a great question. Well, it's so critical in thinking about state versus federal to remember two really big things. The state constitutions are very easy to amend. All right, it takes a 51% vote once it's on the ballot. There are requirements about the legislature, but at the end of the day, it's usually that's 46 states in the country. It's a 51% vote. 23 of them have some kind of direct democracy where they can do initiatives or referenda. And there's only one state in the country that has life tenure the way the federal judges do. It's really amazing. It's Rhode Island. So the smallest and biggest jurisdictions have life tenure. One of us got it wrong. It might be the federal, it'd be my view. So you have at the federal level, the Constitution's unamendable. It takes 3/4 of the states to ratify it. So if it's anything remotely political or about which you have divided opinion, it's going to be very hard to get 3/4 of the states to agree to change the Constitution. And I think that when you say to yourself, I'm struggling with where we are at this moment in constitutional interpretation, we can't even have a common language, I think that's a function of the pressure on federal judges to broadly interpret the U.S. Constitution because it's not amendable. It makes sense that there would be a lot of pressure when there are new norms to use a general clause like due process or equal protection to protect rights. All the federal judges are going to see the problem. Our divide is whether we think we have authority or not. At the state level, it's not as high stakes. In fact, you could argue some of the federal debates don't even make sense. I mean, why would you have a living constitution approach to interpretation at the state level when it's so easy to amend the state constitution or so easy to change the composition through a election selection process of one sort or another? So that question is really important. I think you do see the same debates showing up in state and federal court, but I do think that's why the federal debate is so much more intense, because the stakes are so high. I mean, if the U.S. Supreme Court creates a right through interpretation, that is not fixable by amendment, usually, almost always, and it's only fixable by the randomness of changing the composition of the court. And that's when people die, who's president, who's in control of the Senate. That's randomness.
Just add so sorry, I talk too loud as it is, but add just a point to this. The virtual unamendability of the U.S. Constitution has an implication for the doctrine of precedent. Stare decisis, we call it in law school. Because the U.S. Constitution is virtually unamendable, as Judge Sutton said, the Supreme Court takes it as its own responsibility to correct its errors. And so I think most people think rightly so. U.S. Supreme Court takes the doctrine of precedent a little less rigidly than some people might think. And the doctrine of precedent and statutory interpretation is different, and in the states, common law doctrine of precedent is different. But how about the doctrine of precedent at the state level, where you have an interpretation of the state constitution that says whatever it says? Lawyers come along and say, Your Honors, in the state Supreme Court, you should overturn that precedent. Most of the discussion you see in state courts on this point, and I've read virtually every state constitutional decision in our country for 38 years, the discussion is, well, it's hard to change the Constitution, so we should take the doctrine of precedent a little more loosely. And you go, wait a second, it's pretty darn, it's hardly easy to change a state constitution. But compared to the federal constitution, it's easy. So if that's the case, wouldn't the doctrine of precedent be even more rigid at the state level? Where I watched an oral argument in the Florida Supreme Court last week about an abortion case that was decided protecting a right to reproductive freedom back in 1989. And Florida's Constitution is the single easiest constitution to amend in the United States for reasons I won't go into. The oral argument went forward as though there was no precedent. The justices were going, well, what did it mean back in 1980 when the privacy provision was put into the state constitution? And from the oral argument, it looks like they're going to overturn it. Even though there was a vote in 2012, a vote of the people to overturn it, and it was defeated. And Florida's the easiest in the country. So I think what we've seen too in this moment is a trickle-down effect of probably the Dobbs case overturning Roe versus Wade. So cases, state Supreme Courts in Iowa, North Carolina, South Carolina, did I say North Carolina, are overturning precedents that are 6 months old, 3 years old, pending in Florida, whatever, I can't do the math, but 30-some years old. When in fact, the doctrine of precedent, according to the rationale that the U.S. Supreme Court uses, should be more rigid. But I think we should keep an eye on that, and it looks like the doctrine of precedent is going to be pretty rocky going forward.
To make one final point on that question, one thing, if you become a student of constitutions and read a lot of them, you'll notice that while the federal constitution is actually very short and the language is very abstract in many cases, if you read a typical state constitution, you'll find a lot of material in it that most people would think, well, doesn't that belong in a statute to start with? And there is a tendency, probably connected to this amendability issue, for people to want to put we've got a provision in our Constitution on fishing rights. Now, really, I'm a favorite.
That's what I'm doing this afternoon. This seems very, very important.
Well, be careful,
I'll get
'cause
you a
you've got
copy of my book if you show me where to
constitutional
get a fish.
Well, thank you for those questions. Very thoughtful, and I wish we had time for more, but I want to keep you on schedule because everyone has a busy day. Thank you so much for being here, and much gratitude to our spectacular panelists and visitors to the state of Utah today.
I'll add my thanks. I couldn't be more delighted with this panel. I do want to remind you we have a 15-minute break at 11:30. We have our second session, which will be elections and suffrage in Western state constitutions. We'll be hearing from my friend Dr. Nicholas Cole from Pembroke College, Oxford, alongside some of our student research assistants in the Center for Constitutional Studies who have worked on the NEH project. So I hope you'll be able to join us for that session. We'll see you in 15 minutes. Thank you.